just like to thank Hank for indulging my request that we have a little time to take advantage of the fact that there's this enormous expertise in the room of people who are all interested in this topic of NIPT. And so I would like you to basically do this session. And I thought it would be really interesting to talk about and extend what we've talked about all day about how, if given that we do have non-invasive prenatal testing that is now commercially available, clinically available, how should it be done? And one of the things we've done at our center is to come up with a recommendation, a list of recommendations for best practices for companies. And specifically, given that this is in a sort of company industrial setting, we wanted to focus it on that. So all I'm going to do now is post these, put these up on the slides as a target for you guys to shoot at. And so what I'd like to hear from you is, and we started to talk about some of these things. I think Brian Scottco mentioned a lot of really neat things about education. People have talked about clinical practice in terms of screening versus diagnosis. There's been lots of issues that have been brought up. So what I'd like to do is just show you what we have come up with, and a lot of it's kind of mom and apple pie, so it'll be very easy to critique it and think about what other things should be on this list, what would be on your list if you could talk to the people that are at, is there anybody left from that panel from any of the companies left here? Yeah, you guys, but hardcore. So what would you tell them? No, what would you tell all the companies who are working on creating non-invasive prenatal testing? And so I'll show you, I'm gonna go over this later, but I wanted to start with the practices for the commercial test providers. So I'm gonna just touch on them very briefly, but just to give you some ideas to then build on or trash, or trash these, feel free to trash these or add to them. So one of the things that we had talked about was should this be a direct-to-consumer thing, or should there be a gatekeeper? And so we took a position on that to include clinicians. Also, oversight, even though it may not be required per se, we thought that companies should seek oversight, especially to ensure clinical and analytic validity. We also put in something about international regulations to try to address the really complicated and sticky issue of, say, sex selection and other uses of that, of tests that are available in certain countries, but could be easily provided to people in countries where sex selection is illegal. Number 4 is an interesting one, to require verification of informed consent from clinicians. So that's not necessarily something that all genetic testing companies do, but we were thinking about how should informed consent be done, but also who's responsible for making sure that it happens. And so we placed that burden on companies. So I want to hear more about that from you guys. Also, we talked about samples and how they should be stored in order to preserve privacy and confidentiality. More about informed consent. We talked about consent and institutional review for research done on commercially obtained samples. And also some thinking about capacity to return results based on the wishes of the patients. To provide genetic counseling resources to assist clinicians in facilitating informed consent. So I think some of the companies you heard do some of that, but I'd like to hear more from you about sort of how or what you think about that. To design marketing and advertising materials to promote values-based decision-making and to avoid advocating for specific actions on the basis of test results. So we sort of someone briefly mentioned that in the previous panel about sort of marketing and how is that done. And then also, we had to throw something in there about intellectual property and licensing. And so we wanted to throw something in there about sort of how to do that to equalize access and promote distributive justice. So that's our mom and apple pie. Feel free to chime in about things that we left off or things that you think should be taken off or anything you'd like to send as a message to the industry as they are getting off the ground. Feel free to come up to the microphone, and Hank has one too. You could probably.
Mildred, it's interesting to see, we didn't compare slides beforehand, how nicely those align with what the Down syndrome communities have kind of come up with. I have a question about 4, which I do a lot about, and my question is, who is going to do the requiring? I had asked Mr. Gutierrez, and he said FDA has no precedent for asking any companies who develop laboratory-developed tests to absolutely require verification before they proceed. So if FDA doesn't do it, is it just peer pressure from all of us, and what would get the companies to care about our peer pressure?
Right. So when we use the word require here, we were directing that at companies that would, and urging them to basically do the requiring of their clinicians from whom they are getting samples. So not to just get the sample in the mail and just say, okay, we're going ahead and testing it without having some kind of process for that. So we're asking the companies to do the requiring, and even though they don't have like a legal basis for that.
No, and how do you get the companies to do that?
Well, FDA does that for drugs now. Well, the FDA does that for drugs, for isotretinoin, for
right here, right behind me.
So the FDA can
for a few drugs.
The FDA actually, if you look at the regulation, the law, the FDA actually treats samples with the same rights as human beings. But we actually do enforcement discretion in large part because if we didn't do that, laboratories wouldn't have samples to do most of the development they do, to do QC, to do a whole bunch of things that they do. So we actually exercise enforcement discretion. We could, in another world, I'm not sure, I mean, HHS to a certain extent is looking at some of those issues. You could be very restrictive and ask that they do have those informed consents for everything they do. Right now, that is not done. As long as if it's used for research, it is done. If it's used for anything else, as long as the identifiers are not present, the identified samples, then they are used. We exercise enforcement discretion.
But I think what Al may have been referring to, for some drugs there are risk management programs that do have special requirements for informed consent. Usually I think with the consent of the companies involved, so I'm not sure the FDA actually mandates them, but the FDA negotiates them with companies so that, for example, with retin A, is it retin A? Isotretinoin, this is the okay. So a couple of drugs that are known to have really serious bad side effects in some populations, they'll require particular consent processes, limited number of physicians who are able to prescribe, et cetera. I think that's what you were talking about, right?
Yes. And we could, again, actually the law is even more restricted than that. We just exercise enforcement discretion. We could do that specifically in certain areas if we felt that that was required. Yes. One thing that is not in the list up there that is not really mandated, especially not mandated by CLIA per se, although it's kind of vague, is proficiency testing that I would put, because that's the only way that one laboratory can judge whether it's near the ballpark or not. So carrying some type of proficiency testing program in which a third party provides samples that the laboratory tests blindly would be important, so they can determine whether the results are actually accurate in some way or not.
And so you mean mostly for analytic validity of
That typically is the case, yes.
Yeah.
It's mostly for analytical validity. That's the proficiency testing, like what CAP runs, is that they have samples that they send to laboratories, and the laboratories test, send the samples back, and then the results are compared between laboratories.
As we were talking about these principles, I actually suggested a broader one that didn't make it onto the list, which was I think companies should seek, lobby for, strive for substantial FDA regulation of their tests. I think the companies themselves would be better off if the FDA had a strong regulatory stance here and they could say, our tests have been approved as safe and effective by the FDA. It was thought that asking companies to lobby to regulate themselves seemed a little implausible, but I like the idea anyway. As you know from the last talk, implausibility isn't necessarily a problem for me.
It is number 2 on the list.
Well, sort of. Not with the language I wanted.
I'm interested in number 7, providing selected results. So I think one thing as genetic counselors will wonder about, does that mean going through a list of 20 potential things somebody might find out and saying, do you want to know about all of these or just some of them? And I think what's coming on the horizon is that many of the companies in the area that are now testing for trisomy 21, 13, and 18 all say that soon they're going to add X and Y with the idea that that will give information about Turner syndrome, Klinefelter syndrome, XYY. But at the same time, is that a choice that patients will want to have? Do you want to know this information? Or since these are the less severe versions, is that something you'd opt out of learning? So I just wonder about even a more complicated consent time and explanation of what are all the different pieces. And then as we get into much more of the technology and learning about predisposition genes or single gene issues, how complicated that could get if patients begin to pick and choose what they want to find out about. So,
Yeah, I mean, I think we realize that's a complicated. This is a strong statement and a complicated way, implementation. But I also think that why it's on there is because, first of all, it would be a good reason to have a conversation before the testing was done about all the things you could know, including things you might not want to know, and also raise the issue of how do you honor people's right not to know certain things and not just to have a whole bunch of stuff dumped on them. Now, having said that, we do have microarray testing, which has thousands of things on it that doesn't necessarily get discussed individually, and people don't necessarily have a way of filtering the results. So we don't have a good model for doing that. But I think doing this kind of testing multiplexed to the nth degree in a prenatal setting does demand some thought about how this would be done, if it's possible. But that's a good point.
I wonder if we could deconstruct the informed consent. And I agree that it's a great idea, and I think that it should be done. But is this kind of a California-oriented list? So the California Prenatal Screening Program has a consenting, aspect to it. Not every state's prenatal screening program has a consenting process. Not everybody that does a cytogenetic microarray requests a consenting process. If you get your prostate-specific antigen drawn, there's not a consenting process. So what is it specifically about this test, and I agree it's important, that makes us feel that we want to tell industry that they have to have a consenting process?
Well, I'll put my 2 cents in, but you guys can chime in if you have something to say about it. I mean, my sense was that this was really focused on companies that are providing this as a service that people might be, that it was not, we were not thinking of it as a public health, enterprise, a screening enterprise, but more of a sort of direct-to-consumer or a, as a message to companies that this is not like a public health enterprise. And so it's a different kind of activity. I mean, you have to weigh all those things when you're doing this as a public health screening measure, and you have to make a very conscious decision that you're going to say, we're not asking for consent because it's in the best interests of the population. And this is a very different kind of thing.
So yeah.
Sorry, I think there was an aspect that we...
Grab a mic, Megan.
You took it. I think when we were talking about, there was also an aspect of this being something that was more protective for the companies. Now that prenatal screening gets more and more complicated, lawsuits get more and more complicated, the idea that companies would actually benefit from having clear and sort of legally concise informed consent before they did anything would actually be to their benefit, even if the added step in their process was more complicated. But, they're not a public health agency, so I suppose they don't actually have to get informed consent.
Well, I mean, this is a nice example of the difficulties of legislative history. Mildred, Megan, and I were all in on the drafting of this, and I think we all remember this somewhat differently. So trying to figure out what the framers thought in the Fifth Amendment becomes, it's a nice example of how impossible that can become. For me, part of the sense of consent was, this is a really important set of tests involving which fetuses will continue to become babies and which will not. And second, the concern that as you move from amniocentesis or chorionic villus sampling, if this becomes diagnostic, so big if, but if it becomes diagnostic, with CVS and amniocentesis, the woman is under no illusion that something is clear that something important and complicated is going on. They're going in for an invasive procedure. It's a new procedure. It happens several weeks after they make a decision to do it, et cetera. If it's just another blood draw, I think we were concerned that women would not, as is often reported to be the case already, that women signing a consent form for a blood draw for something might not really understand what it is, and when they get the results back, be shocked and unhappy to discover that they just got information they had no recollection of getting. So for me at least, part of pushing for a strong consent process was to try to make sure that women undergoing this procedure really understood what it was and relying not just on malpractice lawsuits, failure of consent lawsuits, and professional standards to do that, but make the companies, to some extent, enforcers of that.
Yeah, I think it's interesting. So in the history of Huntington's disease, it used to be a very involved process with a detailed informed consent, and you talked to a psychiatrist, and you had a neurologist evaluate you, et cetera, and now it's a blood draw for the most part. And I agree that maybe I should get an informed consent for my PSA, especially after what I read in the news, right? So maybe it's
probably
better off.
Get a PSA.
Right. So I agree. Maybe there's an evolution in the way that this evolves, and early on in the adoption of a test, that's an important aspect that maybe as it becomes more routine, disappears.
And and I guess there's still a question of whether consent requirements vary depending on the nature of the decision that's involved. Is making decisions about prenatal testing, do those involve? Are those more serious than decisions about whether or not you and I are going to get a PSA?
Yeah, but I think we sometimes mystify genetics in a way. So when I get a complete blood count draw, I potentially am diagnosed with leukemia,
right.
And there's not an informed consent process that might happen.
Or familial hypercholesteremia. I mean, a cholesterol count can be a genetic test. I agree with you about that. It's not so much the genetic side of it that I think is exceptional here, as it is the prenatal side somehow. But there are certainly other prenatal tests that are not genetic tests that could be similarly important.
Let's see, I want to nuance 1, I want to flip 10, and I want to add 11.
Okay.
You want fries with any of that? You want fries with any of that?
Nuance 1. I think, especially with the argument about laws against sex selection, I want these tests to be available to the end user and not to be modified through the the doctor both because of price and because of legal requirements. Number 10, I want when the test provider develops information on multiple tests, that the information be public domain rather than us providing intellectual property to this one commercial test provider.
Wait, could you say that again? What is it that you want to go into?
Well, I don't want the test provider to get all the intellectual property. I want it, if it comes from tests that are done on a lot of different people, that information to be in the public domain rather than patentable by him.
You mean the test results?
The
data?
The development of this gene kills people, this gene, etc. The intellectual property that he gets from all of us for developing new tests, new stuff, not to be his personal property, because it's a lot of, we contributed a lot of our genes to developing that.
And what was 11?
I pass.
You can come back if you...
I'm David Hansel, so I'm a technology investor who funds these companies. And the short answer for the genes, I'm an inventor on about, I think, 40 gene patents. I've spent way more on prosecuting, never made a penny for them. They're, you know, with very few exceptions, are they worth any money? I think I'm very concerned with two. Two would be fine if there was any surety with how the regulation would come out. I'm willing to accept technology risk. Can I get this, can I put my millions of dollars in, or my LP's millions of dollars in, to try and address this problem and get it to technically work? But then you're gonna, and then will there be competition, and what are the market risks? Now you want to overlay on that sort of previously non-existing regulatory risk. One of the biggest problems for investors in this world is regulatory risk. So there's no way, right, I'm going to go out and ask for you know, good housekeeping seal of approval, maybe. FDA, not so sure. Informed consent, I don't sign an informed consent on anything else I do, right? Any other test I have, 23andMe or anything else. I understand this is a special case. Having that be the company's responsibility is probably a stretch. And I understand you want to address social shortcomings, but when you have a company that's all of 5 or 6 people and is struggling to have enough capital to live, that's not really their business.
So do you ever download upgrades to your iTunes? And you check the little box saying that I have read and agreed to all these terms?
Oh, God, I sign end-user agreements all the time.
So that is not all that different from informed consent.
Oh, no, but
except that it's clearly not informed.
But that defeats the purpose of your informed consent.
I agree, but you are required to sign things like that regularly. It's just things that are meaningless, as opposed to meaningful. The fact that they're meaningless makes them okay?
Would you like meaningless informed consent?
No.
So, your choice.
Meaningful informed consent. Page 4, I like the page 14 of the iTunes download that I actually once downloaded the whole thing and read it. It was 14 pages. That was several years ago. And it's not really true, but I sometimes joked that the clause about having, if I turned out to be an HLA match, having to give a piece of my liver to Steve Jobs, surprised me.
Do you want to take the issue about the seeking oversight for clinical and analytic validity?
The investors clearly won't want it. The companies clearly won't want it.
And all the companies that you have presenting here were all funded by venture.
Yeah, and I think venture is a wonderful thing. But I also think proof of safety and efficacy is a wonderful thing too. And the question really is, and I see Dr. Gutierrez is in line, so when it gets to be his turn in line, which will come sooner if I shut up quickly, I think the question is really designing a regulatory scheme that minimizes regulatory risk. It's not, and right, we're all in favor of that. Getting there is complicated.
I jumped up because we were discussing informed consent, and I was very interested in number 6, which talks about ensuring informed consent and institutional review for any research done on customer samples. So that would be informed consent by the patient that they will be willing to participate in future R&D for that particular company, and that their sample will be utilized for future publications and so
Yeah,
on,
so
for
I was
future
we were
gene discoveries.
just addressing the issue that, like the scenario with 23andMe, where a person who's a customer of 23andMe sends in their spit sample to 23andMe, signs the click agreement, saying, yes, I consent, because there is a consent form for the commercial use of it, saying, I'm going to get these results back about my ancestry or whatever, but but you're also consenting to research. And so what we wanted to do there is to make sure that people understand that sometimes when you send in your sample, it might be used for more than one thing, not just the commercial activity that's being promised, but also this whole other research thing.
So for
and it's
future
very
biobanks, for example.
Right, and so companies are doing that now, but it's often unclear that when you click on the little box for your consent, that you're actually consenting to more than just getting your own results back, but it's going into a biobank.
I don't think we were endorsing the idea of blank check consent for all future research uses, but saying if there are going to be future research uses, you should at least know about them, be informed about them in a way that gives you a fighting chance of understanding them and consent to them.
And do you know what company, what the company would do if you did not check that you would use your sample for future use? Would they pull that sample? Do you have any idea?
Maybe we should add that to
what the companies would do? Destroy the sample?
But provide the service, but then destroy the sample. Right, that you would have the option of getting the service without your materials being used subsequently for research.
Okay, great, thanks.
Just on that one, I think the experience with neonatal screening that has happened, where there's actually states that were doing research with the samples and they were not consented, and how much trouble they got. So I think you need to consent to be, and if you don't consent, that the sample is destroyed. So that you have to consent into being to have your sample used.
Right.
Not the opposite, which was if you don't click it, you immediately consent. That doesn't work.
Right, kind of an opt-out versus an opt-in.
Yeah, and a little background for those who don't know it, 5.4 million blood spots were incinerated in Texas, left over from neonatal testing, because parents, when they suddenly discovered that their baby's blood spots were being used for research, including research by the FBI on CODIS, which I think parents thought meant that their baby's DNA was now in the offender database, they threw a fit. And ultimately, the legislative settlement involved the destruction of lots and lots of DNAs. And for future use, I think in Texas now, you do have to get the consent from the parents at the time for research. Opt out, but there's at least you get a chance.
I have a somewhat related question. I come from the research side. I actually do mostly data analysis on this stuff, and so I like the list. It's incredibly exhaustive, much better than I could have done, but it has an implicit assumption that there is a test, that you get an answer that you can understand. Anyone. And so I want to throw out the idea that even the people who work in this field all the time presently do not understand. And whether or not we will ever understand a really large test is an open question. And how would you put that in there?
Well, that's a great point.
You're the science
maybe
PhD,
that's
Mildred.
the
You can
number
answer that
11, which we should make number 1. But, well, I mean, we didn't say anything in here. It makes me think we should add something in here, at least about things like determining error rates, determining, setting some minimal standard as an industry about interpretation of tests. But, I mean, what would you recommend as someone who does this kind of data analysis? Is there a way of sort of suggesting some kind of framework to people who do this about, setting standards.
I think of the analogy of diagnostics, where I find that these kind of rules, for instance, diagnostics is a very different business in Europe, where the governments have sort of taken a stance that it's good for society and so on to pool these data and analyze them in an organized, semi-organized fashion. So I think you're facing a challenge here is that the best thing you could do is make all the data public, but there are privacy issues. And I know for a fact that if you show me DNA from a person, I can probably tell you who it is, which is an open secret.
But might that translate to something like setting standards for combining data in databases, minimal data elements, or, in order to create a database that is pooling?
I think, yeah, I mean, the potential is there to do this sort of big data thing that Facebook is trying to do with social networks, where you really start to collect lots of information and see what you find. It's speculation, entirely speculation. But if you could track health data and genetic data and prenatal testing, put it all together, we have the compute power to do it. But anyway, I just wanted to raise the issue that we do not understand it. May not.
There's one loophole that we've kind of alleged or kind of have moved around that nobody's talked about, and I didn't talk about it in my presentation, and that is sex testing, either that or parental or testing for who the father is, who's your daddy type of testing, because right now I don't believe that. Well, I do know. The regulations or the law is written for the FDA is fairly broad, but we have taken a stand, and this was back from when Dan Troy was at the agency, that such testing is not under our purview. And so, so we have not, we have actually moved against certain companies that have included other tests, like a pregnancy test, within their kit. Then the kit becomes both it becomes an FDA cleared device, if you like. But if they're offering parental testing by itself or sex testing by itself, right now I don't believe CLIA would look at it. I don't believe the FDA would look at it.
Or paternity or ancestry.
That's
right?
correct.
Genealogical.
Yeah.
That's an interesting point. I do know people who would take the position that possession of a Y chromosome is a disease, but it's hard to square this. That was a joke. It's hard to, sort of. It is hard to square this with the FDA's jurisdictional statute involving diagnosis, et cetera, of any disease or disease or condition. Yeah, I think it would be a big reach.
So pregnancy testing is done because it's a
condition, right?
We have come down on both sides, I would say, and right now, the last thing that was said stands to a certain extent. We have to revisit that again for any issue.
Which is kind of interesting in a sense, because I think not necessarily safety and efficacy regulation, but in terms of people wanting to prohibit particular uses, sex selection or sex determination would probably be the most popular to restrict.
Thank you for the great presentation. I would have a question on number 9, where you discussed value-based decision making. And I would like to know, how do you define value? Because we have values that pretty is always good, and people who have a lot of money, they are better. And we know there are so many ways where people who don't have kids, who just want kids, it's just because that's the only option they have right now. Can we start some kind of regulation that all of the babies that will be born in Palo Alto will have to be chosen by the state? It means that what we will do, we will have a few model guys, and we will have a few model women, and we will fertilize their eggs based upon our genetic testing. We will find out and then only those pre-fertilized eggs can be considered, that can be, that can be further reproduced by implanting them in a female human body. I think my question is not clear. So what I'm saying, can a state decide the values or any big body, but through advertising or any medium, where we will choose predefined men and predefined women, we fertilize their eggs, and if someone wants kids, then they have to choose those pre-fertilized eggs to have kids. Why it is so necessary for them to have their own kids from their own genes when their genes are not perfect?
I'm still not sure if I understand your question, but I think what we meant by values-based was values of the people making the decision as opposed to other people's values. And also, I think specifically, one of the criticisms that's been raised about information in the prenatal testing situation is that the information that is given to people who are making the decision are getting information that is very much based on the values of the clinical world that they have entered. So a lot of information about sort of disease risk and physical conditions, and not so much quality of life issues or family relationships and other values. So that's what we meant by that.
Yeah, so I guess my question is still vague because I'm still trying to formulate it. So saying that disease, we don't want to have diseases. Now, where we draw a line that what disease we don't want, like someone or some genetic combination is on high probability that he will get migraine or she will get migraine. So can we say that not having migraine is a good thing, or we can live with migraine?
I don't think we're trying to make statements along those lines. Does anybody else want to jump in here? I mean, I don't think we're trying to address these.
Yeah, I don't think that the statement is intended to try and draw those lines. I think that it's really just intended to encourage people to make those decisions on their own, right? So because it's the parents' decision what they think they want their child to live with. And I think that it's intended to encourage that kind of individual choice based on individual values, and not, sort of place exactly the kind of pressure you were talking about, like social pressure about what is a good life and what is a good, healthy life, to try and avoid placing those pressures on the parents so that they can make the most free choice.
I think we have time for one more question or comment.
Thank you. I wanted to address again the question about informed consent, because I think where it sometimes becomes problematic is figuring out who is the responsible funding party, because I'm sure Sharon can share, it costs money to do development for the material, for patient education materials, to provide websites, to provide texting support. All of those things that we've talked about are important to provide patients with the support they need when they're trying to learn about a condition, whether it's the informed consent process or after receiving a diagnosis. So my question, I guess, just to the audience in general is, where does that funding responsibility lie? Is it with with the testing company? Is it with the medical professionals providing the test? Independent organizations? Because, I can attest to the fact that with our materials in particular, it was largely funded by the Kennedy Foundation and our small company. So I'm just wondering how you spread that funding responsibility and who it actually belongs to.
I'll just put my 2 cents. I think we were trying to encourage companies to take some of the responsibility as opposed to putting it all on the clinicians and saying it's your problem to find the brochures or to develop them or figure out what to say, and that, but I think that that's a process that would be better served if it involved a larger group of stakeholders, such as the ones that have been described, where there's a lot of professional societies and other stakeholder groups who get together to develop those. So I think it would be to the advantage of everyone if that was not just a unilateral kind of activity, but we wanted to, I think, encourage the companies to not just assume that the clinicians had it handled, and to take some responsibility for the kind of information, because it's new. Clinicians don't really probably you know, we heard, you know, a lot of people have never heard of it before, and how can they be expected to then explain it?
And it's probably a relatively small amount of money for many of these companies, at least once they get going. Ultimately, who pays that is the customers of the companies, because the companies' prices are a little higher as a result of this. So the company customers, the insurers, Medicaid, et cetera, ultimately would pay for it. But if it's something we think is an important public good, we just want to make sure somebody provides it.
Yeah, I mean, I think it's the same thing. One part of the feedback that we got to these initially was, you know, why do you expect companies to do any of this? You know, why would you expect them to provide genetic counseling or ensure informed consent? And I think it's like the companies we're talking about earlier today. You don't make money off of those added services, but they are necessary in terms of, you know, preventing pushback from your patient population and making sure you don't end up in the newspaper having terrified a bunch of people about their prospects prenatally. And I think I agree that maybe the companies aren't the best people to be making the brochures, because obviously that's a little against their interest to say, you know, some people don't want prenatal testing, and that's perfectly reasonable. But you know, something like an informed consent form, which is a very legalistic document, which helps protect them and the patient, I can see how it would be reasonable to expect companies to put a little bit of money into making sure that, you know, they're getting appropriate consent from the clinicians. I don't think anybody expects the companies to sit down with the patients and do the informed consent process. All we're saying is you need to just require that the doctor check a box that say, I have done a comprehensive informed consent with this patient before you run the samples. I think that's about as much as you can expect them to do.
Well, thanks for your input on this. Thanks for your thoughts.